You're watching Reality Check. In a time when interfaith, Hindu-Muslim love and marriages are facing rising threats across India, a court order has offered a window of hope. The Allahabad High Court has more or less struck down a provision of law that has long been a tool for vigilantes or even families to harass and disrupt Hindu-Muslim couples. This pertains to the Indian Special Marriage Act, used by interfaith couples to get married in this country. One of the most problematic sections of the Act made it mandatory for the couple to give written notice of their marriage to the district official. The notice was made public for 30 days, during which time anyone could raise objections to the marriage. This mandatory 30-day public notice has been used or misused to harass couples. But now, in a 47-page judgment, Justice Vivek Chaudhary of the Allahabad High Court has struck down the mandatory provision of public notice. He's made it optional, leaving it up to the couple to publish or not to publish a notice. In case they don't make such a request, the marriage officer, the order says, shall not publish any such notice or entertain objections to the marriage. The court set out reasons for why it came to this conclusion in its order. It said the publication of notice and inviting objections would invade the fundamental rights of liberty and privacy of the couple. It would be cruel and unethical to force the present generation to follow the customs adopted by a generation living nearly 150 years back, the court said. It also said that marriages under personal law, for example, Hindu or Muslim law, don't require publication of any notice or calling for objections. So there's no reasonable purpose by making the procedure more obstructive under the Special Marriages Act. Now, the court passed the order on a petition by a Muslim woman who'd converted to Hinduism to marry a Hindu man. The petition said her father was not permitting her to live with her husband. After it was established in court that the woman had made her choice of her free will, the father agreed to let his daughter be with her husband. In his judgment, Justice Chaudhary observed this matter could have come to an end at this stage. But because the couple, while interacting with the court, said they could have got married under the Special Marriage Act, but were worried that the 30-day notice clause would invade their privacy and cause social interference, the court decided to examine this rule. The judgment also refers to Uttar Pradesh's infamous so-called love jihad law. The court observed that the woman's lawyers also stated that the situation may become more critical for this couple with the notification of UP's unlawful conversion law, which prohibits the conversion of religion by marriage to be unlawful. Now, since UP's law has come into force, dozens of Muslim men have been arrested, accused of trying to forcibly convert Hindu women for marriage. And while today's order doesn't directly apply to UP's awful law, which is also facing legal challenge, it does do away with at least one route through which interfaith Hindu-Muslim couples were routinely harassed, even arrested. All right, joining me tonight on Reality Check, I have with me Vrinda Grover, advocate of the Supreme Court. Dr. Vamanacharya, senior spokesperson, BJP Karnataka, is here with us. Vakasha Sachdev, associate editor, Legal, The Quint. Ananya Bharadwaj, senior assistant editor, The Print. And Vikram Singh, former DGP, Uttar Pradesh. So, Vrinda Grover, good news doesn't come very often these days, but here is a piece of news that at least offers some kind of window of hope, coming as it does appropriately on Lodi. But tell me, I'm sure there would have been challenges to this particular section, this notice period in the past, but in this case, it actually has been read down. How significant is this?
I think this is a very welcome judgment. In fact, there are presently two challenges to this very provision of the Special Marriage Act, to my knowledge, pending both before the Delhi High Court and the Supreme Court. And I think it's very interesting, as you just narrated, as to how this case came about. It is actually emerging from the lived experience of young people. And these are people who want to solemnize their an interfaith marriage without necessarily. And the Special Marriage Act has become such an impediment and so obstructive, whereas its purpose and objective was so different, that even someone who does not wish to convert, and I have in my own work and in my legal practice interacted with couples where they do not wish to alter their religion in the course of their because they're getting married.
Right.
But they have no option, because a Special Marriage Act is like a red rag not only to families who may be opposing, but actually allows everyone else to interfere.
Right.
And because this publication of notice, and we know that as a matter of practice, there are certain fundamentalist groups which actually regularly visit the marriage registrar's office to see who is applying for interfaith marriage, and then begins a process of hounding them. And this case actually emerges from that situation where, in fact, Muslim woman converts to Hinduism and they say we can't marry under the Special Marriage Act. I think the other very important element that we see here, and this is good news at a time when we are seeing that there is a lot of repressive legislation around right to choice coming up, both in UP, Uttarakhand, Madhya Pradesh, all not surprisingly BJP-ruled states.
So one question. One question that this has been passed by the Allahabad High Court, so obviously it has jurisdiction within Uttar Pradesh, but does this have wider jurisdiction?
Well, no, this will apply only within Uttar Pradesh. In fact, they have asked the marriage registrars across UP. The court asked them to make sure that this is that all are informed that this provision will now be directory, and at the choice, the default will be no notice unless the couple seeking solemnization wants it to be published.
Right. Only then will the notice be put out. Now, Ananya Bharadwaj of the Print. Now, some may ask, why are we doing a whole show just on this one particular provision being made from mandatory to optional? Because it's so important to understand, as Vrinda was saying, and you did a whole piece on this, as to how this notice business is used routinely by right-wing groups to try and, in a way, detect these couples at the registrar's office and then use that as a tool to harass them.
Absolutely. In fact, this judgment has come as a breath of fresh air in this entire scenario that's right now on in UP, because I, in fact, traveled to a lot of places. We scrutinized almost 8 of these cases. And as you pointed out, we had done a piece on how these Hindu fringe groups, including the VHP, or is it the Bajrang Dal or Ashtra Hindu Vahini, this law has actually emboldened these groups to run a parallel policing of sorts. So they, in fact, very boastfully tell us about how they have these moles, these sources in all these registrars' office. They have these people in the police department. They have these people at the magistrate's office who give them tip-offs. In fact, they have these kind of WhatsApp groups in which these tip-offs are put when, say, a couple reaches the office to, in fact, even inquire about the documents that are required to get a marriage registered. In fact, one case that we saw was in Hardoi, in which the couple on 30th November had, in fact, gone to the registrar's office to get their marriage registered under the Special Marriage Act.
Right.
Now, just imagine for a couple who wants to get married, both are majors, they are going to the office just to inquire about the documents that are required to get their marriage registered. There is no angle of any conversion, or there is no angle of any force here. And even
so in
then,
that sense,
these right-wing groups, so they give a tip-off to the girl's father, who comes and then picks up the girl, and then the girl is forced to give a statement saying that the man forced me, and then he's put behind bars.
Right. So in that sense, this is going to make a big difference, we hope. So Dr. Vamanacharya of the BJP, now on the last show, one of our earlier shows, Dr. Vamanacharya, you said that you are all in favor of young people. They should come together. Love should not have any restrictions. So I hope tonight you will join our panel in welcoming this move by the Allahabad High Court, saying, look, it's optional. If you want to give notice, you can. If you don't want to, that's fine too. Dr. Vamanacharya?
Yes.
Can you hear me?
The court has ruled now.
Yes.
And
yes.
Yeah, can you hear me?
Yes,
yeah,
we can hear you.
I can hear you.
Yes, go
can
ahead,
you hear
sir.
me?
Yes, we can hear you. Yes.
Yeah. Whatever court has said, we have to accept for the time being till we go to Supreme Court. Okay.
Oh dear.
Or the one who is hurt by this will go to Supreme Court. Okay. Number one is, in 90% of the Hindu marriages in India or even more are done as per Hindu Marriage Act. They do all marriage formalities and within next 10-15 days they get it registered.
Right.
Whereas in Christians, they have a special law where they go to church and father asks them
Dr.
very
Vamanacharya,
specifically that are there
does this have
any
to do with
objections?
today? No, I am asking we are going into something else. I am saying, do you welcome this? Do you welcome the fact that now interfaith couples do not have to put up this notice which leads to harassment? Simple.
No, it has never led to harassments. It is a welcome act that was there because it was helping the couple in long run to live happily, because one
Sir,
is that
the court
your
is saying,
relatives, friends, everybody know they are.
No, so are you disagreeing, Dr. Vamanacharya, are you
court
disagreeing
say,
with
but
the
you have
Allahabad
asked
High
me
Court?
whether you
Because the
welcome.
Allahabad High Court has said that this publication of the notice is invading the fundamental rights and privacy of the couple.
I know.
The court is saying this.
I know my limitations. I know my limitations. I cannot oppose what court has said. But what still remains to be said outside is there were advantages with a Special Marriage Act. That Special Marriage Act gave first 3 months declaration, then 30 days notice to be given to the marriage officer.
Yes.
That was given because it will be very clear whether the girl or the boy is already married, what is the truth, whether the society has agreed, are there any things hidden? Because marriages are not just one day
that's true,
affair.
but the point
not
is,
just one day
I'll come back to you.
Think of the life of the girl.
I'll come back to you. But the point you're making about the safety and the protection of the couple, the court said that in normal other marriages, which are outside the Special Marriages Act, you don't need to give notice, whether you marry under Hindu law, Muslim law, any law. So why make an exception? But Vrinda Grover, a quick response to you on that. That was there some before I go to the rest of the panel, was there some safeguard that it did provide? And also, is there a possible challenge now to this in the Supreme Court? Could the centre challenge this in the Supreme Court?
Well, I think the fact that young people from different religions will forge an alliance of marriage, which will obviously lead to families and cultures intermingling, is something that I would imagine the BJP would be very frightened, if not terrorized by, and I'm sure they'll find a way to challenge it. So I would not put it past them. And I think that's precisely what we are seeing happening in the country today. The court is upholding fundamental rights of individuals. People want secular principles to flourish. It is the state which is giving the main pushback over here to any kind of constitutional rights that are to be enjoyed or exercised. The real pushback is coming from the state on the aspect of the safety and safeguard for women, because all these things are fired from the shoulders of women. Fraud in marriage, dowry deaths, bride burning, all this honor killing takes place through this nexus of patriarchy, caste, dominant religion, arranged marriages. Not in this way. So the court is very clear that through this we are going to enable the right to liberty, so that privacy, etc., are not footnotes which we are going to read in judgments, but we are going to and exercise that in our lives.
So, but right now, Vakasha Sachdev, it's interesting because you've written a very detailed piece setting out the context of the Special Marriage Act and how, in a way, this provision, this notice provision, which Dr. Vamanacharya says is actually meant to protect couples from any kind of, malfeasance in the marriage, was actually brought in, correct me if I'm wrong, historically it was brought in a way to mollify the sort of the religious or social conservatives within the Congress who had a problem with the Special Marriages Act. So the way to sort of appease them was say, okay, we'll bring in this 30-day notice period.
So this is, I hope I'm audible at this point.
Yes, you are.
The thing is that this was one of the issues which happened in 1954, because now look, these the Act had been around in its original form since 1872. Then there was another change in the 20s. Now, by the time you come to 1954, there were a whole set of root and branch amendments being proposed to it, which were going to get rid of this notice period, because the whole idea was for it to become something which would allow interfaith marriages, intercaste marriages, which obviously was a big deal, because because even though, for instance, an intercaste marriage could be, say, solemnized under the Hindu Marriage Act or those kind of situations, it was very hard because you'd have a priest raise an issue there, or the family raise an issue there. And the whole concept here was the idea being proposed in 54 was to remove those objections. But because at the time, and this was a compromise which ended up having to be arrived, because you had the Hindu personal laws all being amended at that point of time, there was a lot of pushback that why are only the Hindu codes being amended? Even though, of course, at the time you also had, for instance, the Indian Divorce Act, and you had the Indian Succession Act. You had things which were being done even with, say, with some of the other attempts at secular laws as well, and which, for instance, affected the Christian Marriage Act and those kind of things. Those were also being done at the time. But the point was that because of the extensive changes being made in the 50s to the Hindu marriages, there was this massive opposition to say that and so this was almost like a sock which was left behind. And, and we see this over the years. Every time attempts are being made by law commissions to look at it, and this is again highlighted in the judgment, they've raised this issue that there is a danger to couples, there is a risk with this provision for harassment. And multiple times amendments have been suggested to address that issue. But unfortunately, it's just not been taken up by legislatures over the years, because I think of the same issues of the compromise keep coming up, because you've got a law which is allowing interfaith marriages, but we've got to try and have some way to control it, which is, a very, very unfortunate thing.
Right. Which is something, finally, it appears that at least the Allahabad High Court has moved forward on decisively.
And they've been able to do that, thankfully, because of a lot of what the Supreme Court has done over the years, and they've cited those judgments very clearly, which is why I don't think this is going to be a challenge in the Supreme Court cannot quite work, because the judgment is so heavily reliant on so much of Supreme Court
of the Supreme Court's own judgments.
Situational.
Right, I saw that.
When the court look at situational changes, when look at the issue of privacy, of choice, all of these issues are very, very well addressed in the judgment. So, I mean, I can't see any legal infirmities with it. And especially given the discriminatory aspect, it will be very hard to say that, this
so very hard for it to be challenged. Okay, let's see how that goes. Vikram Singh, former DGP Uttar Pradesh, is this in a way then going to remove one particular route or tool through which couples could be harassed, especially now that we're seeing with these UP laws coming in, where earlier it was more sort of the vigilantes, but with the UP law, even the police got into the act. This offers a little breath of hope.
Mr. Jain, please listen very carefully. This 47-page judgment of Justice Vivek Chaudhary is nothing short of a course correction of Section 5, 6 and 7 of the Special Marriages Act. But I would be living in a fool's paradise if I were to say that it will address all the issues that afflict the problem today. In fact, as one of the esteemed panelists mentioned, that there are informers within the court premises, the readers, the lower functionaries who act and are more than willing to supply sensitive information to fringe elements like the Bajrang Dal, the Parishad, Vishwa Hindu Vahini, etc. And then you have a problem. It's only that the notice part has been precluded. But the notice is just a small aspect of the whole problem. Yes, the notice will not be made public. But where there are informers, where money can exchange hands, where there is a direct access to the official files of the registrar's office, the problem begins there also. And I would say that will address maybe about 25% of the problem, but 75% of the problem continues to be at large, and that has to be addressed by society and by the police and the law enforcement agencies.
Right.
Mr.
That's
Jain.
a very interesting point, actually, Ananya, that what Mr. Vikram Singh is saying, that because you still have to give notice, the notice will not have to be published for 30 days, but just the very fact that you give notice at the registrar's office or at the marriage official's office, that itself could tip off troublemakers.
Yes, definitely. I mean, it can create a lot of trouble for the couples. As I said, that in this Hardoi case that I saw, there was not even a notice. They had just reached the registrar's office to know what all documents are actually required for getting the marriage registered, when a tip-off was sent and then a case was filed and the man was then thrown behind the bars. In fact, it's not just one case. We saw so many cases in which this law is being misused. The police, in fact, has dictated the complaints. In one case in Bijnor, the father, in fact, told me that his 16-year-old daughter had just gone out for an outing with a 17-year-old boy. When some people in the village saw them, and then there was a case of this under love jihad or say anti-conversion law against that boy. He was thrown behind the bars. The girl was asked to give a statement. In fact, she told me herself that there was no talk of any sort of conversion, no talk of any sort of marriage. But you can see this kind of trend in most of these cases wherein there are old relationships that the parents did not approve of, and now the police has sort of come into them to separate the couple, and now the man is in the jail while the woman is sitting at home. In fact, this law has not just deepened the communal fault lines on the ground, but has also created that instilled a fear in the minds in villages that we had gone to, in these towns wherein Muslim men and women and mothers of Muslim men have in fact told their sons not to venture out in Hindu villages or befriend Hindu girls. So this this divide is becoming bigger.
It does have consequences beyond, but at least it's a small step forward. Last word from you, Dr. Vamanacharya. Are you indicating that there is likely to be a challenge of this what otherwise would be seen as a very progressive step by the Supreme Court? Because as Vakasha pointed out, the order of the Allahabad High Court draws heavily on previous judgments of the Supreme Court, which have taken a very progressive view about individual liberty.
No, I don't agree. Somebody can go. I do not know the details of the law, whether they can go or otherwise. I am not a legal fraternity. But I definitely feel and believe that people can go because it is in the interest of the couple. If they go without notice, without 30 days notice, there are many problems. If he is already married, other than Muslims, if he is already married, it cannot be known. Because unless the community knows, unless the village knows, it is very difficult to assess what is happening, what is his personal life. Then
why
if he is marrying his very near relatives.
Not there in the normal personal law marriages then? Why is this condition not kept in other marriages, like if you marry under Hindu or Muslim law,
I'll
you
tell
don't have
you
to
why
give notice?
It is not there because the reason is these marriages are done for days together. There is an engagement, people come together, then they celebrate.
What do you mean?
Even before marriage, there are 1 month program going on. Society has taken care. Even
I need a quick...
even in small villages, people know much before. The marriage happens.
I think Vakasha has a quick point and then we have to wrap.
Any valid objections are...
Right. Okay, Vakasha, yes, quickly.
This is again a very quickly. This is a misnomer because while you may have traditions, may say weddings under Hindu Marriage Act, etc., or Muslim marriages can go on for days, that is not part of the legal requirement, right? The Hindu Marriage Act, for instance, if you just have a thing, you could have literally a 10-minute ceremony and be done with the wedding. Now, therefore, if those laws don't have a provision which say that you have to have a notice period and you have to have these objections, and they are saying that there it's perfectly fine for you to later raise the objections, get the marriage declared void, as is the case for other marriages, then there is no reason why in law the Special Marriage Act can't have this. If these are traditions or things, those can't be baked into a law. And that is something which is the key point here.
This special order without notice will open Pandora box of so many problems. This is going to be a big problem if you don't have a notice, especially for this type of marriage.
I think it's a wonderful thing.
Special Marriage Act.
For this contrary suggestion. So,
I think it's a wonderful thing. I think it's going to. I think it's finally giving some hope that you are going to be able to go ahead and marry or have relationships interfaith without this constant fear of harassment and even arrest. So let's see. But let's see how it actually works on the ground.
Lot of
As
problems.
Vikram Singh said, there are still other concerns. But we'll have to leave it there. We're completely out of time. Thank you all so much for joining me on Reality Check. And thank you so much for watching. Good night.